Hey, Janice.
Anthony, how are you?
I'm doing well. And you?
I'm doing well.
Janice, how do you choose the right trustee for your estate?
Great question.
We're going to go, we'll cover that today. Great article from, is this Kiplinger or Kiplinger? I never knew the answer to that. Do you know?
That's another good question. No, I would, potato.
Sure. So this is
Yeah.
Kipling, I'm going to say kiplinger.com, written by Timothy Barrett. Thank you, Timothy. Thank you, Kiplinger. And we're going to talk about how to choose the right trustee for your estate. But before I ask you to kick us off, Janice, I'm going to quickly go over what is a trust, just in case anyone out there is a little unclear. Is that all right?
Perfect. Perfect. Thank you.
So I'm not going to go into the real nitty gritty. I mean, this is, 10, 15-minute podcast. So I'm just going to give the real high level explanation in case anyone, pipes up and says, that's not technically what a trust is. There's more versions of it. I know, I understand. I'm just giving the real back of the napkin explanation. Yeah. Okay. So there's really two main kinds of trusts. One that's sort of a will substitute, and one that kicks in after somebody has passed away. And I'll explain what that means. So the common trust is usually called the grantor's trust, living trust, or rev trust, but a revocable trust, excuse me. What that is because you want so badly to avoid probate when you pass away, you want to avoid the courts when you pass away, for your family. You put everything into a trust while you're living, and you're your own trustee. So for me, it would be, I would sign checks from my trust account as Anthony Park, trustee of the Anthony Park Trust. It's that kind of silly, actually. But the reason you do this is because the moment you pass away, your family doesn't have to go to the courts or do any of that, probate stuff after passing, and the trust sort of handles all that. It has rules and mechanisms in it about who gets what without going through court. I hope I explained that. Does it make sense?
Yes, absolutely.
Okay. And the alternative, the other common trust, is a trust that springs into existence after somebody passes away. And the most common example is if dad passes away, or mom and dad pass away, but they leave behind minor kids. One of the most common and important things you do in your will is make sure that money doesn't go directly to your kids, because kids aren't allowed to owe money. We'll talk about that in another episode. And instead, the money goes into a trust for their benefit. And in that case, you have money that's being monitored, invested, and governed by a trusted individual, your trustee, trusted individual, for the benefit of your kids to be paid out to them when they reach adulthood. All right. So that's another common situation. Does that make sense so far?
Absolutely.
So as we jump into this, Janice, we're talking about two types of trust situations. One where it's really like a will substitute, and your trustee is almost like your executor. And it's almost transactional. Upon your passing, is this trust the right trustee to get you from, get your assets to the next generation? Let's call it that. And then the other situation is where you need somebody to manage money over years until your kids reach adulthood or something along those lines. Make sense?
Yes.
Very good. Would you take us away, please?
Yes. And what I hear from your explanations is that to set this up, or if you're thinking about setting it up, definitely talk to a professional, because there's many ways to go with these trust planning.
I think most people wouldn't even think about these unless they talk to an attorney. So, I hope not.
Do not DIY a trust or estate planning. I feel that's why there are professionals. So,
my answer to that, Janice, is anyone who says, I heard I can DIY it. I'm like, go ahead. Because, that's how I make a good chunk of my living, because at the end, when those things are really messed up and they have to go to probate court, who do you think gets paid? The attorneys, who have to clean up the mess. So whatever.
You get to fix the DIY.
Yeah,
so
pretty much.
PSA statement for the day is just have an attorney do it right the first time. But
please.
Upon deciding on who will be the trustee, there's some questions asked. But first, what is a trustee? What are their specific duties? These include taking care of the interests of the current and future beneficiaries. They're also going to have to be impartial, properly accounting for all of the funds, prudently investing the funds, managing the funds, and following these clear. There's clear rules. I mean, there are rules to be a trustee. You have to follow. So who's going to be the best trustee? First thing they'd bring up here is, should my trustee be my spouse or my child? Of course, when we're talking about child, we have to talk about someone over the age of 18. Mm-hmm. And even then, I wouldn't, it's pretty young. But questions to consider: can your trustee separate his or her personal feelings from those of the other beneficiaries? Will they treat them all fairly? Do they have the ability to analyze investments? So what are some other things you think that they should consider when we're talking about a child or a spouse as a trustee?
Let's cut this in two, and we'll do this for the rest of the points as well. We'll talk about the trustee who's essentially an executor substitute, and then we'll also talk about the trustee as somebody who has sort of an ongoing job over years, managing a fund for whoever the trust beneficiaries are. Okay, so as a executor substitute, and I talk about this in my upcoming book, it's going to be a probate guide titled To Be Determined. In some cases, it makes sense to just, the surviving spouse, because the surviving spouse is so intimately aware of the household finances. It just makes a lot of sense. But when it comes to adult children, the big problem is bias or the perception of bias. Yeah. So if you have more than one kid, you don't want there to be a risk that that the others even think, or even that the seed is even planted in their mind that they're being mistreated or treated unfairly by their older sister or brother, or the case may be. And even if it's not true, right? Even if it's not true, if the situation lends itself to these kinds of creeping thoughts, it can really tear a family apart. So, I often discourage naming the eldest child or the most responsible child. It just seems to cause a lot of problems. I mean, that's been my experience, at least.
Yeah, and even if it isn't necessarily true, like you said, it could be the perception of they picked, child A instead of B and C, and there just could be a problem.
And to roll back to some of the other elements that Timothy talked about, I think we should just assume organized, financially responsible, good credit, understands investments. I mean, those are the kinds of things that I think you would almost just presume would be the case. I'm talking more about relationships, managing people, and how to make sure this doesn't all blow up, if that makes sense.
Right. Absolutely. Because, there's a lot for them to undertake when it comes to this. Yeah. So should my trustee be an attorney, an accountant, or an other trusted advisor? He talks about that this specific group, they have special and trusted relationships with their clients. They understand maybe your financial and personal goals already. They do talk about that hiring, even if it's an attorney or what have you, they may not fully appreciate the scope of the fiduciary duty. Although I disagree with that a little bit, because if you are hiring an attorney for the specific duty, they should know what they're doing. So you might want to make sure you're hiring the right one. Mm-hmm. Does that make sense? So I think I see what he's saying here, that if you hire an attorney, they may or may not know what they're doing. So I would suggest hiring one that this is what he does, he or she.
I've seen personal injury attorneys serve as trustees or executors, and these are really intelligent guys who are really good at what they do, but they don't do this. So a lot of fumbling, a lot of risky behavior that they weren't aware was risky. Like you said, make sure you find somebody who's an attorney, not just an attorney, because there's many kinds of attorneys, an attorney who's experienced in this area.
Yes. And for example, how many have you done? I joke and say one or two, but you're in the hundreds, right?
Right. I want to go around to the courthouses and pull the records to. I think I can prove that I'm the most appointed executor in the at least the 5 boroughs. I mean, the most appointed living. Yeah.
That's a good question to ask when you're sitting down with somebody. How many have you done? Yeah. And if, I joke about one or two, but you're 10, 20, 30. Okay, you have some experience. You talk to someone who said, in the hundreds, I've lost count. That might be a really great person to talk to.
And you're going to see a lot of estate planning attorneys, meaning the attorneys who do your wills or do your trusts, who have never actually probated an estate. And what that means is they've never seen it what happens at the end, how it plays out. So imagine an architect who's never actually erected a building. Is that really somebody you want to work with? I mean, no. I don't know. It feels very academic, doesn't it?
Right. It's almost like, okay, I'm going to give you A and B, but the rest of it, you're on your own. No, I agree with you. And I think that's where you have to really look and talk to somebody, get the information. He talks about appointing a family's estate planning attorney as a trustee, maybe a conflict of interest. How does that work with conflicts? What do you think about that?
There can be some types of conflicts. It really boils down to 2 areas where if the attorney is both earning a commission as a fiduciary and attorney's fees, that can lead to some situations that might affect the attorney's decision making, right? And another is areas of to whom does the attorney owe loyalties, right? So if an attorney has drafted a will or a trust for a husband and wife, and then let's say the husband, it's always the husband, right? The husband passes away, wife is surviving, and there's a trust now, partially paying to the wife and partially paying to the kids, and the attorney is one of the trustees. He also kind of has a pre-existing attorney-client relationship with the spouse. So there's a little bit of at least an appearance of potential conflict. I think that would slide through most courts just because it's very common. But if you can avoid it, if there's an equally good solution that would avoid that, why not, right?
Absolutely. The third and final, I guess not final, but in the article here would be, should the trustee be a bank or a trust company? So that would be more, correct me if I'm wrong, if a trust to a minor child. What do you think? What is your thoughts about a bank or a trust company being the trustee?
Okay, first we need to talk about, is it even an option?
Okay.
Most banks and trust companies have minimums and have a client profile before they'll accept a trust or an estate. And I've seen, I think in most of the country, the minimums are 1 million of investable assets, meaning real estate doesn't count. You need to have cash or brokerage of $1 million in the trust or estate before a bank will even look at you. And I think it's actually more in the greater New York area. I think it's maybe 2 or 3 in this area. So that just kind of knocks out a whole lot of people.
Yeah, definitely.
Right? I mean, I think most people's primary wealth is their home, and if that's not counted, most people aren't sniffing $1 million. I mean, maybe I'm sure there are plenty, but there's others who aren't.
So you have to meet that criteria, which is pretty high up there.
Sure. But once you do, there are some pros and cons. Okay, let's go through the pros, I guess. Pros are banks are immortal, right? If you choose your attorney as an executor, your attorney can die. He can be older than you. He can, get in an accident on vacation. He can die. Banks don't die. They're corporations. You might not have the same employee of the bank servicing you, but the bank will still be there for the most part. Yeah.
Right. As a higher entity, there's going to be more.
The drawback of that is banks merge, get acquired, and change. So you may have loved the white glove touch and feel of I don't know, I'm trying to think of an example of manufacturers Hanover's Trust 20 years ago. I don't know if you even know what that is.
I have no, yep. But
it's been folded many times. It's now part of Chase. And Chase, wow, I don't know if everyone has the same opinions, but Chase is a bit more of a behemoth now. Would you? So,
I will. Yeah, I've helped probate quite a few and dealt with Chase, but yes, it's a very, very big entity.
So even though yes, the entity has been still exists due to its corporate or immortality, it's not the same. It's not the same culture maybe that you signed up with when you first chose them. Yeah.
Right. But they're there. There's, you can still deal with someone at Chase.
Another drawback of banks is that when you choose an executor, a human, I feel like I'm talking about robots, but when you choose an individual executor or trustee, they're also eligible to serve some other roles, such as power of attorney, your healthcare proxy, your burial agent, make some other important decisions for you if you need help in those areas. Banks are just not, corporations in general are just not allowed to serve in those roles. So you'll have to find somebody else anyway. Right?
Yeah, absolutely.
And lastly, the most important reason why, one of the most important reasons why banks are sometimes a bit of a con or a drawback is they're selling you product. So there's definitely a bit of a conflict there. I mean, they want your funds to be with their advisors. They want your accounts opened with them. And naturally, that's what they're in business for. But you need to watch out for those conflicts.
Absolutely. And to finalize the last portion, would having more than one trustee be my best option instead? I don't know that he necessarily answers this, so I'm going to defer to you, but he speaks about, of course, there are successor trustees that you could appoint if something happens to the original. But what about a co-trustee? Someone that has to work together in tandem with another person or non-person, as you said.
My experience, choose one. Too many chefs in the kitchen just leads to a lot of, what do they call it? Terrible soup or stew or something like that.
It's just way too many people in there.
Look, if you trust this person, I love the play on words. If you trust this person to be a trustee, just trust them and let them do it.
Right. Let them do their thing.
And you can build in mechanisms. I don't want to go into all these things on this podcast, but there's things called trust protectors, trust monitors. You can build in so that your cousin or your spouse or your child has the ability to veto or fire the trustee if they don't love what they're doing. There's different mechanisms you can build in. You don't need to have 2, 3, or a committee of trustees, especially if it's a family trust.
And that's a lot of work. If correct me if I'm wrong, but if you have a co-trustee and you have someone living on the East Coast, someone living on the West Coast, and they both have to sign that check,
then the soup gets spoiled, right? I mean, or there's friction that slows things down, and yeah,
it's hard. It is.
All right. Is that the last point, Janice?
It is. And I think we circle back around always to you sit down with the right person to plan your trust, and you will have these put in place originally correctly.
Cool. Thank you, Kiplinger. Thank you, Timothy. And thank you, Janice. Talk to you next time.
Thanks. Talk soon.
Bye.